Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call arraignment. And basically what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. And it is a criminal misdemeanor case. Misdemeanor cases are commonly referred to as your petty offenses. Criminal cases are divided into felonies or misdemeanors. Your felony cases are referred to as your more serious type offenses. Now, that does not mean that your misdemeanor cases are not serious. It just means that they are not as serious as a felony case. And when I use the term serious, what I'm talking about is the facts of the case and the possible punishment that a person can get from being convicted of a felony offense or a misdemeanor offense. Now, if a person had a felony offense, or if you had a felony offense, felonies are divided into 5 categories, and we'll start at the top. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Or if a person is convicted of a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole, or death by lethal injection. As I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about that. For misdemeanor cases, misdemeanors are divided into 3 categories, and we'll start at the top. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors are cases that are normally handled in the JP court, which is the justice court, or the city court, which is the municipal court. Those cases come to this court when a person is convicted in the JP or the misdemeanor court, and then they appeal their case to county court at law. And then it comes up to this court. And the punishment range will be the same. So the punishment range for a Class C misdemeanor is fine only. Normally, the fine is up to $500. Now, if a person failed to pay the fine, or if the fine is converted to community service and they fail to complete the community service, then by them not paying the fine or performing the community service, then a capious pro fine can be issued. What that basically means, the court can issue a warrant for their arrest to set out the fine in jail or pay the fine. Now, if a person has a Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 6 months or 180 days in the county jail, and a fine that does not exceed $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, the range of punishment minimum 0 days to maximum of 365 days, which is a year in the county jail, and a fine that does not exceed $4,000, or you could be given both such fine and confinement. As a defendant in a criminal case, you have rights. Now, one of the rights that I'll talk about, or the first right I'll talk about, is your right to have an attorney. Now, the document that you have on the clipboard, that document is judge's explanation of rights to defendants without attorney. And on that document, it talks about your right to have an attorney. And the paperwork basically states that the first right that you have in terms of right to have an attorney, you have a right to hire your attorney. Now, if you cannot afford to hire an attorney, then you can request that an attorney be appointed to represent you. If you want to represent yourself, then you can waive your right to an attorney, which means you can give up your right to have an attorney and you can represent yourself. Now, that document further states that if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire an attorney, you will have to fill out a financial questionnaire. Now, on the clipboard that you have, the financial questionnaire is the document that is titled Jefferson County Affidavit of Indigence. That's the financial questionnaire that you would have to fill out if you want to apply for a court-appointed attorney. And then once you fill out that financial questionnaire, the proper person will determine whether or not to appoint an attorney to represent you. If you want to waive your right to have an attorney or give up your right to have an attorney, and if you desire to represent yourself, then you can speak to the prosecutor about your case because you're representing yourself. In essence, you are your own attorney. Now, you cannot speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. In essence, you're waiving or giving up your right to have an attorney. The written waiver is a document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. That's the document that is also on that clipboard. And I will go over that document with you in about a minute. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive your right to have an attorney to represent you, you may change your mind at any time. And if once you change your mind, you may request that an attorney be appointed to represent you. Now, at the bottom of that document, it states in bold letters, defendant's choice. And it says, that's the first page on that document. It says, mark your initials on only one choice. So if your choice is to hire an attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request a court-appointed attorney to represent you, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to have an attorney or to give up your right to have an attorney and to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant. And after you sign your name on the line that is titled defendant, then you will place today's date on the line that is titled date. And today's date is September 19th of 2023. Now, for those of you who will be waiving your right or giving up your right to have an attorney, and you will be representing yourself, you will have to sign, you have to read and sign the next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And I'm going to go over this document with you as well. And it states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, which means that you're doing it of your own free will, and intelligently made, which means intelligent, you're saying you know what you're doing. So you're doing it of your own free will and you know what you're doing. It says, furthermore, I have been advised this 19th day of September of 2023 by the County Court at Law, number 2, of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive, which means I wish to give up that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive or give up my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you would date it today's date. And again, today's date is September 19th of 2023. Now, as a defendant in a criminal case, you have other rights. One other right that you have is a right to have a jury trial. For those young people who are sitting in that area over there, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. And as jurors, they will listen to all of the evidence. They will listen to the arguments that the lawyers will make. They will deliberate, and then they will decide whether or not to find you not guilty or guilty. You also have a right to waive your right to have a trial by jury. Waiving your right to have a trial by jury is which it means you're giving up your right to have a trial by jury. And if you waive your right to have a trial by jury or give up your right to have a trial by jury, your case will come before the judge in one of 3 ways. One way it will come before the judge is by way of a bench trial. What a bench trial is a trial by judge only. The judge will listen to the evidence, the judge will listen to the arguments, and then the judge will decide to find you not guilty or guilty. Now, the other way that your case will come before the judge, if you decide to waive your right to a jury trial and waive your right to bench trial, it will come before the judge by way of a plea bargain. It can come before the judge by way of what we call an agreed plea bargain. And what an agreed plea bargain is, a plea bargain is basically an agreement that you have reached with the district attorney's office to settle your case. And so if you have reached agreement with the district attorney's office to settle your case, then that agreement will come before the judge, and the judge can either accept or reject the agreement. If the judge accepts the agreement, if you decide within 30 days that you would like to appeal your case to a higher court, then you would have to get permission from the judge to appeal your case. And if the judge gives you permission, your case will be appealed or will go up to the Ninth Court of Appeals, which is right above us on the third floor. They will review your case, and then they can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas, and it's located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means that you will be filing this petition without the assistance of an attorney. You'll be doing it of your own. And you'll be asking the Texas Court of Appeals to review your case to see whether or not you've been wrongfully convicted, or whether or not this court has committed an error by convicting you, or whether or not your appeal should have been granted. Now, they can do one or two things. They can grant or deny your pro se petition. If they grant your pro se petition, they can just simply find you not guilty. Or they can send your case to the Ninth Court of Appeals, asking them to review it again, or they can send it back down to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, the other way that your case will come before the court, I said it was three ways. One was by way of a bench trial. The other one was by way of an agreed plea bargain agreement. The third way is by way of an unagreed plea bargain agreement. Unagreed just simply means that you and the state have not been able to reach an agreement to settle your case. And so you want the judge to assess the punishment. You want the judge to give the punishment. And so we call that an unagreed plea bargain agreement. Now, another right that you have as a defendant in a criminal case, you have a right to have witnesses to come to court in your case. When witnesses do, they can testify for you or they can testify against you. Now, if you represent yourself or if you have an attorney representing you, then they can be asked questions by either you if you represent yourself or by your attorney if your attorney is representing you. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. Now, what that basically means is you will not be calling witnesses. It does not mean that the state will not be calling witnesses. Now, you also have a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your case. State of Texas, District Attorney's Office, the government cannot force you to testify against yourself in your case. They call that the Fifth Amendment right against self-incrimination. I know at times you may have heard people say, well, I take the Fifth. That means that I'm not going to say anything. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And if you do that, you will be taking the witness stand. You also have a right to have discovery. Discovery means you have a right to have access to the evidence that the state will be using against you in your case. That is, you have a right to witness statements, your statements, police reports, lab reports, any documents that they have that they'll be using. You have a right to have access to any instruments that they'll be using, any video recordings or audio recording. You'll have a right to have access to that evidence. We call that discovery. Now, you also have a right to waive or give up your right to have discovery, which means by waiving your right to have discovery, you will not be having access to the evidence that the state has against you because you're saying that I don't want to have access to it. So you're waiving or giving up your right to discovery. Now, everyone that's here today, you're out on bond, you're either out on what we call a cash bond, which means you pay the full amount of the bond to get out of jail, or you're out on a surety bond, which means that you pay the bondsman a percentage of the bond to get out of jail, or you are out on what we call a PR or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance. Now, every day that you spent in jail, that jail time can be used as credit toward your punishment. So, for example, let's say you spent 5 days in jail and you've talked to the district attorney's office. Y'all worked out an agreement. The district attorney's office is offering you 5 days in jail as punishment in the case. What that means is because you've already served 5 days in jail, you would not have to serve another 5 days in jail because you'll be given credit for the time that you've already served. And if the state is offering 7 days in jail and you did 5 days in jail, that means you would only have to do 2 days in jail because you get credit for the 5 that you've already spent in jail. Now, every day that you spent in jail also can be used toward your fine and court costs. So every day that you spent in jail, that's $100 that will go toward your fine and court costs. So if you spent 5 days in jail, that's $500 that can go toward your fine and court costs. So if the state is offering fine and court costs of $500, you won't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired, which means you won't have to pay it. Now, if they're offering fine and court costs of $700, that means you would have to pay $200 on the day of the plea. Now, if you cannot pay the $200 on the day of the plea, then we can put you on what is called a payment plan, where you'll pay it off in monthly installments. Now, even if we put you on a payment plan and you will still be unable to pay off the fine and court costs, then we can convert the fine and court costs to community service. If we convert it to community service, then every 1 hour of community service that you perform at a local nonprofit organization, you will have $12.50 that will go toward payment of your fine and court costs. So if you work 8 hours of community service in one day, that's $100 that will go toward your fine and court costs. So in the scenario that I gave, when a person owes $200, you work 2 8-hour days at a nonprofit organization, that's $200 that will go toward payment and pay off the balance of your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. So if you've never been in trouble before, it's first time getting in trouble, you did not have a criminal record, Jefferson County has a program where they will dismiss your case. And not only will they dismiss your case, but once you finish the program, you can get it expunged from your record. Expunged means erased, deleted, or wiped off from your criminal record. In essence, it's almost like it never happened. In order to qualify for the program, you have to have an attorney to assist you to get in the program. It cannot be for an offense that involves unlawfully carrying a weapon or resisting arrest, and it has to be your first time getting in trouble. Now, if you are a veteran of any one of the branches of the United States military, the Jefferson County District Attorney's Office also has a program that is called Veterans Court. It's for veterans only. In order to qualify for the program, you just have to be a veteran to get into the program. And if you qualify for the program, you get into the program and complete the program, they will dismiss your case. And you can get what is called a non-disclosure. A non-disclosure basically means that we cannot disclose to the public the fact that you were on deferred probation for this case. Now, we can't disclose it to the general public. However, governmental entities such as the police department, they can have access to it, but the general public cannot. Now, this court has a program that is called the CSI program. CSI stands for Community Safety Initiative. That is a program that I started in March of 2017, within the first 100 days of taking office. With that program, the program is designed to address the issue of what we call recidivism. Recidivism means people committing crimes over and over. And so with that program, we have partnerships with agencies in our local community. One of the agencies that we have a partnership with is the Spindletop Center. The people that I introduced to you earlier, they're from Spindletop Center. They're going to come to you a little later and tell you more about their program. But basically, the partnership that we have with Spindletop, what Spindletop will do, they can conduct private interviews, either here, the courthouse, their office, or maybe by telephone. They can also do what we call an assessment. And they will also be able to do a diagnose, they can develop a treatment plan, either for outpatient, inpatient. This for individuals, you don't have to be insane. You don't have to be incompetent to be in the program. The program is deal with individuals who might be suffering from, you may suffer from anxiety, or you may suffer from depression, or a whole host of other mental illnesses. Spindletop Center has the capability to address your mental health needs. Now, we also have a partnership with Spindletop. They have a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And the local Drug and Alcohol Council has a program that is called OZAR. OZAR stands for Outreach, Screening, and Referral. Both of those programs are programs that they can address people who have issues. You may have issues with drugs, or you may have issues with alcohol. They can address those issues. They can do a private screening. They can develop a treatment plan, an assessment, and a treatment plan for either outpatient, inpatient, depending on what your needs are. Now, if you are unemployed and do not have a job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And once you are trained in any one of those areas that you are trained in, then they will assist you at getting a job in the area that you're trained in. Now, if you have not graduated from high school and you would like to get your graduate equivalency diploma, which is the GED, then Lamar University has a GED program. Now, all of these programs that I just mentioned to you are free. It does not cost you anything but some time to participate in those programs. And speaking of time, I like to say in this court, we do not just give time, we take our time. And what we mean by that is we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And we believe that productive people will not commit crimes. Why? Because they have too much to lose. And so in County Court at Law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And by making a difference in their lives, we also will be making a difference in their homes. And by making a difference in their homes, we also will be making a difference in our community, because the people that comes out of the home will go into the community. And so with this program, as I mentioned earlier, is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our families, and go to church. So if you're interested in any one of these programs, just let us know. We have brochures here with a lot of information that can direct you in the right direction. And to get you on the path of being productive. Now, I mentioned to you earlier that we have some folks from Spindletop who is going to come before you. And at this time, we have Deputy Hinton and Gabby that's going to come before you today and tell you a little bit more about the program that Spindletop has to offer. Deputy Hinton and Gabby.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I am a licensed mental health deputy in the state of Texas. This is my coworker, Gabby. Now, Gabby is a qualified mental health professional. The reason we are both here this morning is because the judge cares about every single person that comes before the bench. What the judge has found, statistics prove, is those who have legal issues commonly have mental health needs, such as use disorders, or sometimes just a lack of community resources to help you with your particular situation.
And so what he means by mental health, he means just anxiety from being here. It could be anxiety about the court process, it's anxiety about outward influences that you have now that you're in court too. So it's common stuff that everybody really deals with, and just nervousness, or just sadness and the letdown that you have right now, possibly. And so we deal with that. It's nothing like extreme. It can be just if you want to talk today, or if you're feeling nervous, or if you want to ask us questions, you're more than welcome to walk. But yeah, what we mean by that, it's we're here for you, and these are just nothing to add on to you. We don't want to add on to any of the costs. We don't want to add on to more of the time, but we want to be here to help you as best as we can.
Maybe this is your first time to be here, maybe it's your 10th time to be here. There's still hope. What we're offering you today has the ability to change your life, but we're going to need something from you. We're going to need you to share that need with us so we can best figure out how to serve you and help you that you connect with the services. And Gabby's going to show you how to do that very privately. The documents that she handed out when you came in is not a court document. It's separate. We're the only ones that see it. We're not here to embarrass anyone, but it will be a basis where we can use that to help you.
So this allows me to contact y'all by text. I'll be contacting y'all by text messages once, and it'll be by my number. I have a word phone that I use with Spindletop, and I'll be the only one. And so that allows me to assess if y'all would like to get a call on, or if you would like to just continue to communicate through text messages also. It will allow me to do that with this document. This information is not shared with anybody else except for me. I will be putting a document here in Tristan. It's not a robocall or anything like that. And so I'm Gabby. So if you receive a text message, it's gonna be hi. It's gonna be like hi. It's from Gabby. So it'll be really clear. It won't be from anybody else. On here, you're gonna see a couple of things. One of those important things right here is your resource request. You're gonna check one of these boxes that you think is more applicable to your life. If there is anything specific, there is an other on here, and you can write specifically what you want on here also. Please, give us a good contact information if you would like to contact you.
Now, just in case this doesn't apply to you, we will be glad to work through you to a family member or a friend or someone you may be thinking about right now that we'll be able to help you get this information to. But that would be up to you. Also have this flyer I'm going to give you before you leave here today. On the back, it tells you the advantages of participating, but also it has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help. Thank you very much. In just a little bit, the judge is going to go into recess. When he does, we'll be able to come out, visit with you, pick up those forms, and I'll hand this out to you as well. Thank you, Your Honor.
Okay, thank you, Deputy Hinton and Gabby. Now, ladies and gentlemen, the paperwork that you have on the clipboard, we have our court personnel here who will be happy to assist anyone that needs assistance with filling out the paperwork. And then we're going to pick the paperwork up from you. And then once we pick the paperwork up from you, it's going to take us a few minutes to go through all of the paperwork. And once we go through all of the paperwork, we're going to call you up before the bench one at a time. Now, as I mentioned earlier, it's going to take us a little time to do that. If you need to use the restroom, there are 2 restrooms right outside in the hallway. The men's restroom is in front of County Court Law number 3, which is right next door. And the women's restroom is across the hall in front of the 172nd District Court. So again, at this time, we're going to go into recess. Now, Do not leave the courthouse. Okay, if you leave the courthouse and if your name is called, and if you're not here, it may result in what we call a bond forfeiture. And basically what that is, a warrant will be issued for your arrest for failing to reappear here in court because your case is not over. So at this time, we're going to go into recess. Folks from Spindletop is going to come out and visit with you. And then we also will have our court personnel who's going to come and help fill out the paperwork. Okay. But at this time, the court will be in recess.